Action Visa Assistance is not a law firm. We do not provide legal advice. This information is for educational purposes only based on the USIS I-9 Central website and our past experience with the H-2 programs. This is not to be considered as rendering legal, immigration, and/or other professional advice. Should you feel you need legal advice, please contact a board-certified attorney or a certified tax professional. Thank you. Hi. My name is Douglas, and on behalf of the staff here at Action Visa, welcome to our webinar on the Form I-9. As your agent, we want to help you to be as compliant as possible, and given the recent increase in the number of I-9 audits going out to employers, it's more important now than ever for you to have this information properly recorded and retained in your files. The information in this video is taken directly from the USIS webpage for the Form I-9 at www.usis.gov/I-9. As of November 6, 1986, the Immigration and Nationality Act makes it against the law to knowingly hire any person who is not authorized to work in the United States. If you hire a person for wages or any other type of payment, you must fill out an I-9. Now, the form is not difficult to fill out, but it does require some attention to details. The I-9 also applies to your H-2 workers. All new hires must completely enter all of their information in Section 1 of the form on their very first paid day of employment. Employers must complete Section 2 of the form by the third day of work. There are some workers the I-9 doesn't apply to, although you generally won't encounter this as an H-2 employer. For people doing domestic work in a private home on a periodic or intermittent basis, independent contractors, or the employees of staffing or leasing firms, and then for people not working in the USA, those individuals do not require an I-9. Now, I do need to say that federal law prohibits hiring an independent contractor knowing that they are not authorized to work in the U.S. The employee must choose the documentation they present to establish their authorization to work. You, the employer, cannot discriminate against any form that is specified in List A, B, or C that the employee submits. As long as the document being presented is on the list of accepted documents and the document is not damaged beyond repair or unreadable, you must accept the forms being presented. You also need to remember that it is illegal to discriminate against any person based on citizenship status, immigration status, or national origin. Please remember that you cannot refuse to offer employment, nor can you refuse to continue to hire a person based on the expiration date of a presented document. This is Section 1 of the form. The information here should always be entered or corrected by the employee. This section identifies the worker in detail, and it also identifies the documentation that proves his or her immigration status and lawful presence. This must be filled out on their first paid day of employment. We recommend that you make copies of all the H-2 workers' information and then immediately return the original documents back to the worker. You cannot keep any of their original documents, not even for safekeeping. Have the worker complete this section while they're still in the office and have someone help translate if necessary. The employer can act as a translator, and any assistance with translation has to be documented. Verify the employee's information is complete and legible before the worker leaves the office. Employees commonly fail to fully fill out the form. They neglect to enter full names, dates of birth, addresses, and if married, employees often fail to enter the maiden name. Employees often forget to select their citizenship status, as well as neglect to identify the documents they're presenting to show an authorized presence. Many employees also forget to check the box that states either they did or they did not require the use of the services of a translator. If a translator was used, or if multiple people helped the employee translate the information, the employer must make sure the employee checked the "did use a translator" box, and each translator must sign off on the document, including the full names, addresses, and the date the translation was accomplished. This is Section 2 of the form. The employer must list the employee's information from Section 1. Then identify and list each of the documents being presented by the employee used to prove their lawful presence and their authorization to work, then must sign off as the official representative of the company who has verified the information to be true and correct. At At the very top of Section 2, the employer must enter the employee's full name, last, first, middle initial, and their immigration status as recorded in Section 1. Employers also have to remember to completely fill in all of the information for the List A or the Lists B and C documents that are being presented. You need to remember to include the title of the document so the document you're submitting is clearly identified to the reader. H-2 employees will most likely, but not necessarily, use one of the List A documents. They would be required to use both the passport and their Form I-94 or the Form I-94A with their endorsement of status. Most, but not all of U.S. workers will provide a List B and C document such as a driver's license or a voter registration card and a Social Security card to show their work authorization. The List B documents are included with the instructions that come with the I-9, but include driver's licenses, state-issued IDs, and school IDs that bear a description and a photograph, voters' registration cards, military IDs, and dependent military IDs, as well as U.S. Coast Guard Merchant Mariner cards, Native American tribal documents, and any driver's license issued by a Canadian government authority. Instructions for the form also list the acceptable List C documents, which include Social Security cards that are valid for employment, birth certificates, Native American tribal documents, U.S. citizen ID cards, and U.S. Department of Homeland Security issued employment authorization. Many employers either neglect to fully complete the form or they fail to complete it within the required first 3 days of employment. Employers must remember to enter all the applicable information, including the title, name, and address of the business, the employee's date of hire, and the employer's representative has to remember to sign, date, add their title, and their full name to the form. Again, employers need to complete this no later than the third day of employment. However, for any employee hired for 3 days or less, the employer must accomplish their Section 2 on the same day the employee is hired and fills out their Section 1 of the form. Section 3 of the form is used for rehires. Many employers fail to enter the employee's full name at the top of Section 3. They also fail to enter the title of the document, the number or expiration date for the acceptable documents being presented, and they fail to enter the date of rehire if applicable. Now, please remember, if an employee has married or has had a name change, that also needs to be entered, and you need to remember to sign, date, and enter the employer's name, and you need to remember to complete Section 3 before the employee's work authorization has expired. The USIS I-9 Central website offers a downloadable PDF that you can fill out electronically, save and submit, or print for the workers to complete manually. When filling out the form, the information must be clearly legible. We recommend that the employee fill out Section 1 while they're in the office and you're making the copies of their documentation. Make certain that you return the original documents back to the workers. You cannot retain them. Review the employee's information in Section 1 and have the employee make any required corrections while they're in the office and available to you. Make sure that the date entered in Section 2 as the start date matches the start date in your payroll records. Make sure that any hole punches, staple, highlighting marks, etc. don't interfere with the ability of someone to read the document. And if you make copies of any supporting documents, those copies also need to be legible. If you decide to use abbreviations, make sure they are generally, clearly, and easily understood, and make sure that all applicable sections are filled out. You need to make sure you're using the current version of the I-9. It should have a published date of July 2018. And the only Spanish version of the I-9 that is available is if you're in Puerto Rico. You must make sure not to discriminate against any of the documents being presented, as long as they are legible and they're acceptable documents on either List A, B, or C. You must accept any documents that the worker is presenting. Please remember that only the employee can make changes or corrections in Section 1. If you discover an error in Section 1 of the employee's Form I-9, you should ask your employee to correct the error. If you need to make corrections on a form, draw a line through the incorrect information, then enter the correct information. Initial and date next to the correction or corrections you made. Now, if you have to make multiple corrections, you can either redo the section on a new Form I-9 and attach it to the old form. You can also complete a new I-9 if there are major errors, such as an entire section is left blank, or if the employer completed Section 2 based on unacceptable documents. If you have to do this, notice, a note should be included in the file regarding the reason you made changes to an existing I-9 or why you completed a new I-9. Other than correcting simple notation errors when copying document information, it is important not to attempt to conceal any changes made on the I-9. Doing so may lead to increased liability under federal immigration law. If you had to make changes on an I-9 and you use correction fluid, we recommend that you attach a signed and dated note to the corrected form explaining what happened. Now, a word of warning for employers. If you happen to receive a notice that the information submitted by a worker is incorrect or that it doesn't match their records, don't automatically assume the worker is lying or that they're giving you fraudulent information. Life happens. People move, they lose documents, they get married, divorced, and people make mistakes when entering information or when reading information. You need to give the employee an opportunity to either present another authorized or acceptable document, or you need to give them a reasonable amount of time to correct the situation. Document your follow-up with the employee for the resolution. You don't want a lawsuit alleging discrimination or wrongful termination brought about by the EEOC. We recommend that you file and maintain all of your I-9s together, however, separate from time cards, payroll, wage information, etc. That ends the information on the I-9. If you have any questions, please feel free to contact us, or you can go directly to USIS at their website, www.usis.gov/I-9. Thank you.